the guests that are present as well as the department which is present today. Okay. Before any further delays, honorable members, can I check? I know it's a Friday today. Can I check? Are there any apologies?
Good morning, Honorable Chair, honorable members, and our guest. Just one apology, Chair, from Mr. Mahlale. He is on the platform and would like to be excused by 10:30 as he's boarding a flight. Thank you, Chair.
Okay.
Chairperson. Chairperson, I have a similar problem, and if we're not done by the time I need to leave, please would you excuse me as well?
What's the time?
Chair, I need to be out of here by 10 o'clock.
Okay, now let's
see how we go.
Thank you.
Thank you.
This is a progressive committee, I know. Mr. Kotze and Ms. Boss, can we see the agenda, please? Okay. Oh, sorry, Parliamentary Service. I forgot that you were here. Oh, no. Now I'm reminded. I said, honorable members were just dealing with issues that relate to the legal opinion, specifically with regards to legislation. Members, after the word adopted, there was an issue which arose with regards the status of the bill that the department has briefed us. We therefore requested legal services. I don't think it's going to be a long meeting. Can I, Advocate Jenkins and your team, welcome. Can I then give it to you in terms of your legal opinion on the matters or two matters that were referred to you?
Thank you. Good morning, Chairperson and honorable members. Thank you for the opportunity, Chair. My colleague, Mr. Tatiana, is here, Andile Tatiana, and he's going to take the committee through the opinion that we did for you. Thank you.
Good morning, Honorable Chairperson, honorable members, and good morning to my colleagues as well. Chairperson, I'll try to summarize. I think primarily, Chair, there were two legal questions that were posed, to legal services regarding this matter. And I think I'm going to confine myself, Chair, to those two questions. The first question, Chair, is about the legal implications of lapsing of a bill. I won't have much in terms of giving you the entire background, because I know for a fact that the committee is aware of what the background is to this matter. Safe to say, Chair, that we deal with that in terms of our opinion at paragraph 17, where we submit that the information that has been placed before us indicates that the MPRD amendment bill lapsed at the end of April 2019. And we say, Chair, that the effect of this is that the bill became invalid and has no force or effect. This is due to the fact that a bill by its nature is draft legislation or proposed legislation of Parliament that has been introduced in Parliament. We say a bill is not law, Chair, and not all bills become acts or law. Some bills do lapse as this one and need to be reintroduced if there is a need to do so. The issue, Chair, that I want to raise in relation to that as well is that if you go to the rules, and I want to liken this, Chair, if you may allow me to draw this analogy to a marriage, Chair. I mean, you know, Chair, that if you want to end a marriage when two spouses are still alive, there are certain formalities which one has to undertake. And I think if you look at Rule 277, Chair, which speaks to the notice withdrawing proposed legislation, it sets out, Chair, when the bill is live before the House, what should be done. But I think in this instance, Chair, you have a situation where the bill has lapsed. And if I were to take you back to the analogy I made regarding marriage, is that when one of the spouses dies, I mean, the marriage comes to an end. So, Chair, that is our interpretation in terms of question one. And then question two, Chair, relates to whether it is legal to designate a non-existing company to implement certain aspects certain aspects of legislation. And we deal with that, Chair, in paragraph 20 to 24 of the legal opinion. If you look at the bill, Chair, you will see that at 111.1 and 2, it says that this act is called the Upstream Petroleum Resources Development Act 2021 and comes into operation on a date fixed by the President by proclamation in the Gazette. And subsection 2 says different dates may be so fixed in respect of different provisions. And we say, Chair, in terms of the Interpretation Act, particularly section 13, subsection 3, it provides that if any act provides that act shall come into operation on a date fixed by the President or the Premier of a province by proclamation in the Gazette, it shall be deemed that different dates may be so fixed in respect of different provisions of that act. And we say, Chair, that the legal effect of that provision is that the law allows the designation of a non-existing company to implement certain aspects of legislation. However, we say, Chair, the sections of the UPRD bill that deal with the SOE in question cannot be promulgated up until the entity is established. Now, there's another issue, Chair, which relates to this, which I want to deal with as well. And sometimes I know it creates confusion, is the issue of who is the promulgating authority, Chair, in terms of legislation. And I know, Chair, this sometimes brings some confusion. The fact of the matter, Chair, is that when the President promulgates, the President does that on behalf of Parliament. So in actual fact, it's Parliament that is the promulgating authority. And I want to take you, Chair, to paragraph 12 of the Pharmaceutical Manufacturers Association judgment, where it says, where the Constitutional Court said, often as in the present case, administrative preparations are required to be made as a prerequisite to bringing the legislation into effect, and it is best left to the executive branch of government to determine when the appropriate time has arrived. In the constitutional structure of this country, it is the President as the head of the executive branch of government who is the appropriate person to whom to delegate that power. However, the power that he exercises in that regard is one that is delegated to him by Parliament and not one that is conferred upon him by the Constitution. Chair, we then say that in terms of our advice, which is captured, Chair, from paragraph 25 to paragraph 27 of the opinion, we say that in view of the foregoing, a bill is not law, and the legal effect of it lapsing is that it is invalid and of no force or effect. The law allows the designation of a non-existing company to implement some aspects of legislation. However, the sections of the UPRD bill that deal with the SOE in question cannot be promulgated up until the entities is established. Put differently, those sections that deal with the SOE in question can be passed by Parliament and assented to and signed by the President but cannot be promulgated up until the entity is established. We so advise, Chair. Thank you very much.
Don't rush us, Ari. We are still dealing with this. Honorable members, let me then say, when we dealt with this issue, we were called by the department. The concern was about the MPRDA amendment bill, which was referred to the committee it was referred back to Parliament by the President. And then subsequently, the committee dealt with it. It went to the NCOP. The fifth Parliament came to an end. The legal challenge was whether can you then deal with a bill that takes or comes from a bill that was not finalized. Therefore, we needed clarity on the status of the MPRD amendment bill, which is why we asked legal services. The second thing was the fact that on the bill that is being proposed, the Upstream Petroleum Development, the Petroleum Resources Development Bill, there is reference to a state-owned national petroleum company, which at this stage we don't have it. Now the question was whether the bill, if we proceed with it, won't have legal implications if we take that tune. I'm not sure whether honorable members would want to have questions of clarity. I hope Mr. Jenkins and Mr. Ntejane, you will also clarify the matter. The difference on the MPRD amendment bill is that it went through the National Assembly, it was passed, it went through the NCOP, it was returned by the President on the grounds that it does not meet certain requirements. One, at the level of the NCOP, that there was no proper consultation. The second part was that from even the National Assembly, there were substantive issues. Those include the issues that relate to international agreements that the country has and so forth. So it's not the same. I realize when we're dealing with this thing that it's not the same like a bill introduced by the minister. Whether now a bill referred back by the President can just lapse simply because the fifth or the administration had come to an end at that period. But let me check with honorable members whether they do have other questions with regard to the legal opinion. I can't see hands here. It seems your advice is an acceptable one. Just clarify me this with the small part, and also on the promulgation, because my understanding the promulgation is the last step by the President. And what if the President returns it back and say it does not meet the constitutional master on the basis that it makes reference to the point that you were talking about, and therefore, is it possible that the promulgation is or how that selective process on the promulgation ensues? Let me give it to you, Mr. Ntejane and Mr. Jenkins. I can see there is no response on the matter for now.
Good morning, Chair, again. Chair, for me, just to simplify the matter, for me, Chair, the fact of the matter is that it's a bill. As I said, Parliament is the promulgating authority. The President does it on behalf of Parliament. Whether the bill has been referred back by the President and so on, the fact of the matter is that it remains a bill. And when it lapses, Chair, it means that it has got no legal force or effect. Thank you, Chair.
Then I'm answered. It remains a bill. Okay, you wanted to come in, Advocate Jenkins?
Yeah, thank you, Chair. Just specific to your question, I mean, if the President, if he has a constitutional concern about the establishment of the of the company in there. I mean, one will deal with it then as per the constitutional procedure, but I can assure you that it's that act of bringing the legislation into operation, not even the signing of it, but bringing it, the promulgation. If at that point you cannot give effect to the legislation because certain regulations are not in place or that company is not established, then we'll have a problem like the court case that my colleague, Mr. Tatiana, referred to. But as it stands at the moment, it's not a problem. And the bill that lapsed, as Mr. Tatiana said, it's dead until the House decides to revive it. But now that we have a bill before us, even that decision from the House, one will question, because we have a bill before us which we can work with. So I think we're on solid ground, Chair. Thank you very much.
Okay, thank you very much, Legal Services, for your, at least now we are on the clear, we can continue and move on. Can I then take members to one matter, Ari? I think this one last is just to confer to members, because it's just an instruction or a correspondence to us. Ari? Yes, honorable members, I just received, I think I did receive the letter from the House Chair. I don't think the letter was only for my attention. Now, this, I won't go to many of the things. It says, as you are aware, the mining company Glencore has pledged guilty before the US authority on charges of corruption in a number of countries where it operates. Glencore International has pleaded guilty and agreed to pay $1.1 billion US dollars, equivalent to 18.4 million in fines and penalties for corrupt practices in dealing with foreign governments. The international company made headlines around the world for corruption and a bribery network that sought to advance the company's international influence. Glencore is a major role player in the mining sector in South Africa, and its South African representative, Mr. Ivan Kloisenberg, should be in a position to clarify their local activities with Parliament. It would be appreciated if you could please appraise my office as to how the committee intends exercising its oversight responsibilities relating to this matter, as enshrined by the Constitution of the Republic of South Africa and the rules of the National Assembly. Yours sincerely, that is from the House Chairperson. I can say, honorable members, I didn't want to send a correspondence, but I know the answer would be simple if the members agree with it, that I will be able to say the committee last week, or this week, I'm saying last week, this week on the 30th, ne? Yes, dealt with the matter, and the matter has been referred for legal and research to the legal and research units of Parliament so that they will be able to guide. But I think it will be enough to say the committee has initiated a process to deal with the matter, and it will give feedback as and when it is necessary. But can I leave it to you so that if I don't speak wrongly on your behalf? Honorable Lorima, I see your hand. Is there any other hand? Okay, let me hear you, Honorable Lorima.
Yeah, thanks, Mr. Chair. I mean, I agree with the step you proposed as a first step, but in a sense, we're not really making any decisions about what to do, and I think we need to start thinking about that. The situation is that Glencore has proved itself to be involved in massive bribery across the world. We know that we've had issues with bribery of officials in our country. It is a fair assumption that that may well have happened here. So the question is, do we now go back to every license that has been issued to Glencore, every inspection that has taken place at a Glencore mine, and look and see whether it was justified or not? So that would be the correct thing to do. It's quite a lot of work. It's not something the committee can do. I don't think it's something we can ask the DMR to do, because then we're asking them to investigate themselves. I don't think we can, at this stage, get Glencore in because, you know, they're very likely to deny it. It's almost like we need a third party to conduct that investigation. These are just thoughts, Mr. Chair. I put them out there.
Thank you for your thoughts. I hope we know that you have already commissioned legal services and to also give us the parameters and the research. I think when the research they come and present to us, as well as then we will take I think that's when the committee takes a decision on what route to take. If we need a third party or some other support system, it's common knowledge. But let me not enter that terrain. I know sometimes it's a common knowledge that we're asked to do something. When we ask for support system, it's nowhere to be found. Honorable Kula and then Honorable Milam.
No, thanks, Comrade Chairman. Greetings to you as our chair and colleagues on the platform. Chair, I think the suggestion that you have came with is the best suggestions, that we need to wait for legal and research to then come back to us. Once they've come back to us, we can then input as a committee based on what research is saying and what the legal is saying on the best way forward to deal with this matter of Glencore. But I want to emphasize that we will not play kids' gloves on this matter. We will give it the necessary attention that it deserves. So I think let's not jump the gun. Let's not be ahead of ourselves. Let's wait for that which we are saying we must wait for. Once we have received it, it will then empower us as this committee on the best way to deal with this matter. But we will be seized with this matter and we will deal with it to its satisfaction. Thanks, Chairperson.
Honorable Milam.
Thank you, Chairperson. Chairperson, I just want to draw your attention to one of the facts in this matter, and that is that Glencore has pled guilty to a number of charges in the US of corruption in various countries. And I think a good starting point for our investigation, or whatever you want to call it, or our research, let's call it research at this point, a good starting point would be to obtain any documentary evidence or plea agreements or settlement agreements or whatever it might be that the US has in this regard, specifically the Securities and Exchange Commission of the United States and whoever else may be involved in this matter. Thank you, Chair.
Thank you, Honorable Milam. I'm sure research and legal services stay here. I know even myself in my mind, I've always been having my own nightmares on what could be the best. But I'm sure let's just leave it for now at that level. Can I then let's agree that we'll write to the House Chair and say this committee has started the process of how to deal with the matter, and I will then outline what steps have been taken. On that note, honorable members,
Chair, before you close, I saw the hand of Mr. Mahlaule. I don't know whether he put it down again.
Oh, I didn't see. Mayor Mahlaule.
Thanks, Chair. Before you closed on the matter, I wanted to suggest that we probably need to take Honorable Lorima's point, specifically on the investigations around the licenses, the issuing of licenses, and bear in mind that he has a point that we can't ask that from the department because the department would be investigating itself. But as a point of reference, I think we must agree that the legal services and the research that would be done to pave a way on how we deal with this matter must also look at how we can approach that point, because it's a very important point that I think will be central into the consequences of all these things that we are hearing about, that in fact, things that they have confirmed in other countries that they've been doing. Thank you very much.
Okay, no. That's accommodated, and fortunately they are here. On that note, honorable members, sorry, Honorable Mahlale, I really didn't see your hand. At least you are even an hour and 5 minutes before, and Honorable Milam is even 35 minutes before the time he requested an apology. On that note, honorable members, the meeting stands adjourned. Thank you very much.
Chair.
Have a lovely weekend and other colleagues.
Oh, you wanted us to remain behind. Hey, sorry.
Yes, Chair.
Yes, Chair.
I nearly left you.
And Frankie and Andile as well, Chair.
We should just adopt them in this committee. But TK.
Hey, let's hope the Glencore issue does not cause divisions to your side. Bye.
Yeah, justice must remain, is correct.
Mandin Shea, Chair.
Oh, as an important president. Hi, what a bye bye.